Welcome to the Ohio Department of Insurance Issuer MHPAEA Compliance Training. I'm Laura Miller, and I'm the Assistant Director of Product Regulation and Actuarial Services here at the department. Like in previous years, we have a team consisting of product regulation, legal, and market conduct reviewing the MHPAEA compliance filings. However, this year, ODI is working with consultants Sam Uzinski, Tim Clement, and Marilyn Badon. They are advising us on our compliance tools, review of the compliance submissions, and conducting this issuer training. Ultimately, though, ODI is responsible for the analysis and final disposition of the compliance filings. I hope you find this training helpful, and of course, if you have any questions, please send them to us. We've set up a dedicated email address, MHPAEA Compliance Questions @insurance.ohio.gov. That email will be given again later in case you didn't get it right now. Now, I'll turn it over to Sam.
Hello, my name is Sam Uzinski. I'm one of the consultants working with the Ohio Department of Insurance. And I briefly want to touch on what we're going to cover during this session about the filings that you're going to be doing with the Ohio Department. One, what the department really wants to do is assist issuers in securing compliance with MHPAEA. And the focus and objective is on guidance directed towards helping insurers complete the reporting documents. The process is there is a prescribed format for your reporting on financial requirements, quantitative treatment limitations, and non-quantitative treatment limitations. And ODI will assess the reporting sufficiency and will provide feedback to the issuer as the process unfolds. So what we're going to do during this session is we're going to review a few of the essential MHPAEA rules which precede testing. We're going to review rules which are specific to the testing. And then we're going to review and discuss the issuer reporting materials. And then we're going to review guidance about compliance reporting and criteria for assessment of the sufficiency of you as an issuer's response. Tim, did you want to comment a little bit on the work with the issuers?
Yes, absolutely. Thanks, Sam. So the purpose of this whole exercise is really, the reporting is to help the issuers, make sure that they are in compliance. It's not to try to go on a finding mission to intentionally discover that issuers are out of compliance. And we want to work with issuers to make sure that they come into compliance, they understand all that is necessary to be in compliance. So we just want to understand this is intended to be a collaborative relationship between the department and the issuers in terms of securing MHPAEA compliance.
Okay, we can go to the next slide. Okay, as a prelude to a more specific discussion about the testing and materials, we want to go through a few things about steps in the rules that actually precede the formulation of the classifications which become the cells for testing. So specifically, one thing to keep in mind, which is fundamental, is that the rules in the MHPAEA regulations are sequential and interrelated and serve as the basis for the proper classification of benefits. And it's important to understand, in a sense, they're almost building blocks as to what you need to do prior to proper classification. The assumption by the Ohio Department of Insurance is that the classifications were properly configured and that you should have the documentation to support compliance with the rules which precede classification. Marilyn, do you want to comment?
Yeah, I just think it's important to note that the classifications are the cells for testing. And it is really important to make sure that the classifications comply with the rules, or the testing, either quantitative or non-quantitative, may not be valid.
Okay, we can go to the next slide. All right, so this is a brief review, and some will be familiar with this, some may be less familiar. But again, the rules are sequential and interrelated. So rule number one is that you have to define mental health conditions and substance use disorders consistent with a recognized standard of care. And in this case, we probably most likely be referring to the Diagnostic and Statistical Manual, or the ICD-10. Now, the plan definition of mental health and substance use disorder benefits and what the plan provides coverage for are actually based on the definition of the diagnoses. So for example, that if we're looking at the ICD-10, they would all be listed as F-code diagnoses, and anything that was provided in connection with a primary diagnosis of mental health and substance use disorder would have an F-code, and benefits, any and all benefits that attach to that F-code treatment episode are considered MH and SUD benefits. So then, but once we have the disorders defined and the benefits, we get to the issue of how we are going to classify the benefits, and there are specific rules that govern the determination of the classifications and subclassifications, and we'll return to that shortly. And then for each of the classifications and subclassifications, there are specific testing requirements for financial requirements and quantitative treatment limitations, which we may jointly refer to at different points in the presentation as just quantitative limitations. And then there's a specific separate regulatory test for non-quantitative treatment limitations. And essential and important and underscored to keep in mind that there is a specific prohibition on separate financial requirements or treatment limitations, whether quantitative or non-quantitative, that's statutorily regulated. So if there is the point simply being, you can't have a separate requirement. It has to have a correlate on the medical surgical side if it's going to be applied to the mental health substance use disorder benefits, and it meets the specific regulatory tests, whether quantitative or non-quantitative. Next slide. Okay, briefly, as I mentioned, what rule number one is, we have to define the disorders. And again, the DSM or the ICD-10 are going to be the recognized standards of independent care. There's only one exception to that, and that is if state law specifically defines something that's otherwise considered a mental health or substance use condition as medical. There are no laws in Ohio which permit any commonly recognized mental health substance use disorder by the DSM or the ICD-10 as a medical condition. So that in this case, we're home free. Different states have different requirements. Then what we need to understand is that once we have those disorders defined, we need to identify all items and services that are provided for both mental health and substance use disorders and medical surgical conditions. I will refer to them as dual benefits, and we may refer to them likewise further out, but Marilyn's going to explain it a little bit more.
Right. So as Sam said, items or services provided for both MHSUD and medical surgical conditions are referred to as dual benefits. An example of this is rehabilitative and habilitative services that are provided in connection with MHSUD conditions. These are then MHSUD services. Examples of this would be occupational therapy provided for mental health conditions, nutritional counseling for eating disorders, and lab testing regarding substance use disorders. So any expenditures for these services, when provided for an MHSUD condition, need to be separated out for the predominant and substantially all testing. Financial requirements and quantitative treatment limitations cannot be applied if the testing fails. So visit limits cannot be applied for these services when provided for MHSUDs unless they meet the test.
Yeah, the only amplifying point I'd make about that is it's sometimes services are thought of as exclusively provided with respect to a medical condition. But some of those services, as Marilyn just mentioned, are also provided in connection with a mental health substance use disorder condition. By definition, under the regulations, those are also mental health and substance use disorder benefits. Jim, we can go to the next slide.
Okay, so getting into the classification of benefit rules. So all plans must be classified into one of the 6 classifications or permissible subclassifications. Obviously, the main 6 classifications are inpatient in-network, inpatient out-of-network, outpatient in-network, outpatient out-of-network, prescription drugs, and pharmacy. And of course, one thing to note for any of the issuers that have no network, if you have no network, then for the purpose of the reporting and for this exercise, those should be considered as out-of-network benefits. So if there is no network, then all benefits are considered out-of-network. So it'd be inpatient out-of-network, outpatient out-of-network. And now, of course, there is no right way to necessarily assign benefits into a classification, but once you've selected a method for determining which benefits go into which classifications, you need to use that very same standard for mental health substance use disorders as you do for medical and surgical. So there can't be a different standard for assigning benefits, but there is no per se right way to do it. It's just that you have to use the same one for mental health and substance use disorders as you do for medical and surgical. And of course, benefits for mental health and substance use disorder must be provided in every classification in which benefits for medical and surgical conditions are provided. So for instance, if you provide inpatient out-of-network medical surgical benefits, then you have to provide inpatient out-of-network mental health and substance use disorder benefits. In other words, you can't exclude out-of-network coverage for inpatient mental health and substance use disorder care as a categorical exclusion if you do in fact cover it for medical and surgical. And then when you have subclassifications, particularly when classifications and subclassifications are established, they are fixed for the purposes of all testing. That's financial requirement, quantitative, and NQTL testing. And one place where this comes up is subclassifications. The most prevalent subclassification is the outpatient in-network office visits, and then all other outpatient services. So that's the main subclassification. The office visit classifications are the office visits, and then the outpatient other that are not office visits or in subclassifications. One thing you have to understand, though, is once you have established that, say, you are going to subclassify, you have to that is fixed for not just your quantitative testing, but also for NQTLs as well. As the federal regulator once said to me, the standard is pick and stick. So if you've picked the subclassifications, you must stick with the subclassifications, including for NQTL testing. So even though the financial requirement, even though subclassifications, the offices and outpatient other subclassifications were primarily created for the purpose of financial requirement and quantitative treatment limitation testing. However, if you carefully read the text of the final rules, they do apply uniformly to all treatment limitations, including NQTL. So if you pick subclassifications, office visit, and outpatient other, you need to retain those subclassifications for all forms of testing. And of course, testing must occur independently for each type of financial requirement, quantitative treatment limitation, or NQTL within each classification and subclassification.
Yeah, I would only offer a couple of points of emphasis on that, Tim, which overlaps with what you're saying. One is that the subclassification rules are really important, and the DOL self-compliance tool, which is listed as a resource for this exercise at the end, provides a lot of clarification about that. But where the other subclassification that may be relevant for some of the issuers is where you have tiered your provider networks. Those are subclassifications, and you got to test separately for all quantitative and non-quantitative limitations across each provider network. So we can go to the next slide. Okay, the predominant and substantially all tests is pretty straightforward, although there are additional considerations when there's more than one level of copay or coinsurance or whatever in determining the predominant amount. But we're not going to go into that in great detail other than to do the top line issue, which is really essential and often not addressed, is that you can't apply any financial requirement, quantitative treatment limitation to mental health and substance use benefits unless it applies to 2/3 of the medical surgical benefits within the same class. If and only if you pass that 2/3 test, then you go to the predominant test. If you don't test it, if it doesn't pass that test, then you simply can't apply it. This becomes important, as we kind of were suggesting before with the dual benefits issues, that even if you have visit limits on physical, occupational, speech therapy, unless they pass the 2/3 test, you cannot apply them to the mental health substance use benefits when provided with an MHSUD diagnosis. You could continue to apply them for those kinds of services when associated with a medical condition, but not with an MHSUD condition. If you have passed the 2/3 threshold, then you can go on to determine what the predominant amount is. And the predominant amount is that level of FR or QTL has to be applied to more than 50% of the benefits in the classification or its respective subclassification, if applicable. And again, to be redundant on purpose, the rule applies to each distinct type of FR or QTL and not FRs or QTLs as a class. So a common error we have seen, which may not be relevant for this audience, but we've seen it, is combining coinsurance and copays as a financial requirement. They are two distinctly different kinds of FRs, and they have to be tested separately. The only other thing I would offer is that the DOL self-compliance tool is a really good, important resource for this, because beyond what we're covering here with the tests today, there are many considerations regarding the calculations of the expected plan dollar amount payments to be paid for the plan year that's being utilized for the testing. Again, the DOL self-compliance tool provides specific and detailed guidance on the essential considerations and calculations, and questions about that should be posed after a review of that if you are not familiar with that material. Yeah, we can go to the next slide.
I'll just chime in very quickly here.
Sure.
As Sam noted, the DOL self-compliance tool, if any of this is fuzzy to you, and we know that the actual text of the final rules for this can be a little bit intimidating at first, but I think the DOL self-compliance tool has some very good examples that can help you understand substantially on predominant tests. And just one thing, just a special note of caution, not to say that this will apply for any of you, but if you do subclassify into outpatient office visits, do make sure that you are passing the substantially all test. Don't just assume that if you apply the lowest level of cost sharing, let's say you're using copays and it's the $15 copay, that's the lowest one you have for medical and surgical, so you're going to do that for mental health substance use disorder, you should be fine. Remember, in the office visit subclassification, there are a lot of preventive care visits that do not have and are not allowed to have any cost sharing associated with them. Those count towards the expected plan payment threshold that you would use to calculate the 2/3 ratio. So just make sure that you are passing the substantially all test if you're subclassifying into offices, because as we've seen in other experiences, that sometimes is problematic. So just do make sure that when you're doing the office visits that if you do subclassify, that you are in fact passing the substantially all test.
Okay, to review so that we're all on the same page, is that financial requirements and quantitative treatment limitations take numerous forms. So the financial requirements typically include, and these are the essential ones really, deductibles, co-payments, co-insurance, or out-of-pocket maximums. Again, they're distinct types and need to be tested separately. A reminder that separate cumulative financial requirements are expressly prohibited by the law regulation, that you can't have a separately accumulating deductible for mental health versus medical conditions. With respect to quantitative treatment limitations, that limits can be based on a variety of things that are quantitative. It could be treatment frequency. It could be number of visits, typically visit limits. It could be days of coverage. It could be days in a waiting period. And also sometimes what appears are visits or days per episode or similar that are attached to a specific treatment episode. Those would be prohibited unless they pass the substantially all test. So separate cumulative quantitative treatment limitations, like their financial requirements counterpart, are not permissible either. So you can't accumulate days of coverage, number of visits, anything that applies specifically to MHSUD conditions and not to medical conditions. Tim, did you want to comment on the annual lifetime limits?
Yes, I did. So if you look at the final rules, 45 CFR 146.136, you will notice there is a lot of dense and potentially confusing text about annual or lifetime dollar limits. You don't need to worry about that because of the Affordable Care Act. That is essentially irrelevant for the audience that is watching this presentation. So do yourself a favor and don't worry about the very confusing looking annual and lifetime limit language within the final rules. It's not going to be relevant for issuers in the individual and small group market. So just wanted to make sure that you're clear about that. If you do happen to wade into the rules and see that and wonder, what about this? There's a 1/3, then a 2/3, then a 1. Don't worry about that section of the rules. It's not relevant for the individual and small group market. Okay, so now what I'm going to do is, just so no one gets whiplash here, we're going to stop the presentation for just a moment and bring up one of the spreadsheet that you all will be completing. So I'm going to stop the slideshow here and then jump into the spreadsheet. So we'll get back to some of the other components in here that I know some of you had some questions about, some of the data reporting that's associated with the non-quantitative side. But for now, we're just looking at the spreadsheet as it relates to financial requirements and quantitative treatment limitations for the purpose of substantially all and predominant test. So if you notice here, again, the substantially all test is described briefly here, the passing the 2/3 ratio. And of course, that 2/3 ratio is expected planned payments for medical and surgical benefits in a classification. So in other words, that's how you do the calculations, is that's where you would establish the 2/3 ratio if it applies to more than 2/3 of expected planned payments. And of course, the predominant test is the level that applies to more than 50% of the financial requirement that of the benefits that are subject to that particular financial requirement. So what this spreadsheet here does is it doesn't ask this. You don't have to show your math for how you established that you passed the substantial all test. You just needed to show what your results were. So for example, you need to show, let's assume that you did the substantially all and predominant testing, and then you list the type of financial requirement or quantitative treatment limitation, if that does in fact come into play. Most likely this will be just for financial requirements. You will list the type of financial requirement. You'll say what the level is. So this is co-insurance, it's 20%. Then you'll list what classification or subclassification we're talking about. In this example, it's inpatient and network. And then you'll say what the results were for the substantially all test. So when you did the substantially all testing for this example, the co-insurance applied to 80% of expected planned payments on medical surgical in the inpatient and network classification. Okay, if you pass the substantially all test with flying colors, with room to spare, then obviously you are allowed to apply co-insurance to mental health substance use disorder benefits in the inpatient and network classification. Okay, so what was the result of the predominant testing? What was the one where you found what the predominant level was? Well, you found that 20%, that was the predominant level, and you found that 70% of the benefits subject to co-insurance had that 20% co-insurance rate associated with it. Therefore, it clearly passes the predominant test, and that means you are allowed to use the 20% co-insurance for mental health substance disorder. If you wanted, for some reason, to apply a 10% co-insurance to mental health or substance use disorder, you certainly could do that. The predominant test just establishes what the most restrictive level is that you can use. So you can't use anything more than 20%, but you could use less than 20%, but you certainly may use 20% as it is. So again, that's the purpose of this spreadsheet, is we're not asking for the actuarial results and the testing, and and again, there's some good guidance in the self-compliance tool about doing some of the testing, but for the purpose of this exercise, you're not expected to show the math, you're just expected to show what the answer was. Okay, and with that, we will close this out and move back.
I would only offer Tim as additive to that, which is probably obvious, but again, the department has a dedicated email box where there are questions about this, and any and all questions are game about filling it out, or questions about expected plan payments. Did we do the right thing? Or you saw something in the DOL self-compliance tool, which again is a great resource for this, that was confusing or you didn't understand. Those are all fair game to enter as questions, and in fact, welcome them where there may be confusion. That's all.
Yes, please do ask questions if you're not sure about anything, because we understand that this can be, the rules are very dense and can be somewhat intimidating. So if you do have any questions, we are always, the department is always happy to answer those questions.
Okay, so I think now we're moving on to non-quantitative treatment limitations, or NQTLs. An NQTL is a health plan feature which is not expressed numerically, but otherwise affects the scope or duration of a benefit. There are a number of enumerated NQTLs, which include utilization management protocols, network adequacy, reimbursement rates, and coding edits. However, the NQTLs that will be required for the 2023 plan year are prior authorization and concurrent review. ODI intends to require reporting on different NQTLs in the future, but for plan year 2023, it's prior authorization and concurrent review.
Okay.
We can go on to the next one, Tim.
So rather than dedicating a slide to the text from the final rules, we're going to actually jump out of the presentation again, and we're going to bring up the, let's see here, make sure I got the right. Yes. So here we have, this is the non-quantitative, as you can see on the screen here, this is the text right here. You can see why we didn't put this on a slide. It is very, very dense, but we will read it. A group health plan, or in your case, health insurance coverage, may not impose a non-quantitative treatment limitation with respect to mental health or substance use or benefits in any classification unless under the terms of the plan or health insurance coverage in your case, as written in operation, any processes, strategies, evidentiary standards, or other factors used applying the non-quantitative treatment limitation to mental health or substance use or benefits in the classification are comparable to and are applied no more stringently than the processes, strategies, evidentiary standards, or other factors used in applying the limitation with respect to medical surgical benefits in the classification. Obviously, just reading that once, I'm sure everyone has understood that completely and totally, and there's no need to further go into it. No, I'm just kidding. As you can see, this is a very, very, very dense requirement, and I'm sure all of you are familiar with this and have read through and wrestled with it at times. But because of the density of these rules, of this particular rule here, it can be quite challenging. But we should not confuse density for ambiguity. This is not ambiguous. It's actually very clear once you pull it apart and think it through. But as we've just seen here, it is very dense. So now what we'll do is we will jump back into the slideshow, and we will unbundle the requirements of the NQTL testing of that language. So the first thing to understand is the universe that we're talking about when we deal with NQTLs are as written and in operation. So that's what the landscape we're looking at. We're looking at things that are as written. And then we're also looking at things that are in operation, that take place in operation. That's a very key component that we'll get back to in a little bit. Okay, what are the units of analyses? What are the things that, as written and in operation, we're interested in testing to determine compliance? And those are the processes, the strategies, the evidentiary standards, and other factors. And what we're looking to do is we're looking for these processes, the strategies, or the evidentiary standards or factors that apply to mental health and substance use disorder benefits when applying a non-quantitative treatment limitation, and how they compare to the medical and surgical benefits. So that's the test for each of these terms, both as written, and then you have them separately in operation. So you would have to do separate testing and analysis for as written in operation, but you need the test those four terms must pass for mental health and substance use benefits is they must be comparable to and applied no more stringently. And of course, compared to medical and surgical. So you're comparing Any processes, let's say you have processes in operation that occur for mental health and substance use disorder, and of course they also occur for medical and surgical, you would need to be comparing those to make sure that they are in fact comparable and applied no more stringently. And of course, the testing is all for NQTLs is done within the respective classification or subclassification. So in other words, when we're talking about prior authorization, any in-operation processes that occur during the inpatient in-network for prior authorization for mental health, substance use, or medical surgical, you compare them within the classification. So you're not jumping across classifications. So in other words, if you're testing prior authorization for inpatient in-network, that's all you're going to be looking at is information within that cell. You don't look at, say, outpatient in-network when you're doing that testing. So all the testing is contained within each respective classification or subclassification. Marilyn, do you want to add something?
Yeah, I mean, just to reiterate that the rule is about comparative analysis as between MHSUD benefits and medical surgical benefits. So you have to compare the two benefits. So the NQTL that's applied to the mental health and substance use disorder benefits are to be comparable to and applied no more stringently than the NQTL that is applied to the medical surgical benefit.
Yes, and I just might add before we go over to the next slide that is true. I mean, as you can see, the text from the final rules is fundamentally comparative in nature. Now, of course, we do have the new statutory requirement added by the 116th Congress and signed into law by President Trump in December of 2020 that does make it explicit that you must do comparative analyses. However, just fundamentally, the only way you could really know whether you meet these tests are as if you had done some sort of comparison and analysis. There'd really be no other way to tell. So it's there's always fundamentally been a comparative analysis component to non-quantitative treatment limitation compliance.
So Tim, I would add on, if you go back for a second, that to give a simple example of the last point there about testing in each respective classification or subclassification, because it's actually seen this, where the plan / issuer had, for purposes of classification, subdivided the inpatient, outpatient other, and for the quantitative testing, and it was performed accurately. But then when they did the NQTL testing, they lumped a number of things from the outpatient other category, like partial hospitalization or medicated assisted treatment, back into the inpatient category because they said, well, we prior auth in the inpatient classification across the board, and we do it here. That's not valid. The testing in the outpatient other classification, in this case for partial hospitalization and intensive outpatient, needs to be tested with that it's comparable to everything else that's being prior auth or not within that outpatient other subclassification. So, as Marilyn pointed out, and as Tim has driven home, that the entirety of the NQTL rule in most respects is driven by a comparative analysis. And so what do we mean by comparative analysis? Well, we would be the first to acknowledge that any kind of standard definitions of comparable actually has two different meanings. It can be identical or similar, and we recognize both with some qualifiers. So comparative analysis is just not describing something, it's actually comparing and contrasting two distinct sets of information. To say that policies and procedures are identical for everything doesn't really explain whether in fact they are different or demonstrate that they are the same in toto as written. So we want a relational explanation as to both the similarities and the differences. Now here's where it comes home for the dual definition of comparable, is that differences in factors, processes, strategies, and so on are not dispositive of non-compliance. Everything does not need to be identical. Everything does not need to be identical. Repeat it. But where there are differences, they must be explained and a rationale must be offered as to why they are comparable. Similarly, identical results for in-operation data are not proof of compliance. Most folks are familiar with the kind of what we call the disparate results doctrine, that, you know, disparate results are not indicative of non-compliance so long as the processes, strategies, etc. are applied comparable. That's true, and we recognize that. But what's also true is the inverse, and this point will probably be repeated, is that similar results of in-operation data or even identical results of in-operation data are not proof of compliance either. So, descriptive tests, side-by-side presentations, summaries, or declaratory statements are not detailed comparative examinations or explanations, and then we'll further expound on this a little bit as we get into the comparative analysis requirements of federal law. And matters declared as the same must provide an explanation or illustration as to why they are the same, not just a simple statement that they are the same. Marilyn, you got a comment?
Yeah, and I think, you know, my comment goes to the differences. I think you pointed out very clearly that just because there are differences doesn't mean that there's a violation of the law. However, the differences need to be explained and a reasonable rationale provided as to why there are differences. But it doesn't have to be identical.
And I would just add something to the bullet point there about descriptive text and side-by-side presentations. So then this comes into play mostly when it comes to demonstrating in-operation compliance. Merely describing, let's say, in-operation processes that occur during concurrent review, inpatient, and network, and saying that these processes occur. There's a first level utilization reviewer, then who can approve but cannot deny authorizations. Then there's the second level physician reviewer who can make a denial, and just describing that there are certain processes that take place in operation and saying that those very same processes take place in operation for mental health and substance use disorder as for medical and surgical. That's merely a description. That's good. That's a good start, describing what those in operation processes are. But then you have to provide the actual demonstration of proof that they did in fact occur in a comparable and no more stringent fashion. So in other words, if I were to say that, you know, Sam and I both drove our cars to work today, and we both drove on a highway, and we both parked in the parking garage. Therefore, we drove our cars to work in a comparable and no more stringent fashion. I did not demonstrate that by describing what we did. I would have to actually show, because for all I know, what I just described there about Sam and I driving our cars to work, maybe Sam was cautious, assertive yet cautious, looked both ways, stopped every time at a stop sign, went the speed limit, used turn signals properly, and parked in a single parking spot in the parking garage, while I drove 110 miles per hour, didn't stop at any stop signs, didn't wear a seatbelt, didn't use any turn signals, and took up 3 parking spots when I got into the garage. We certainly did not drive to work in a comparable and no more stringent fashion, but just by describing that we did drive to work, we did drive on a highway, we both did park in a parking garage. Superficially, that might seem like you've produced some sort of demonstration that things that occurred, you know, were basically the same, but it did not in fact perform the comparative analysis of getting into analyzing what exactly happened and demonstrating that it was in fact comparable and no more stringent. So I just want to, I know we're sort of harping on this one, but again, we have seen this quite a bit, and just listing things and describing things that happen, particularly in operation, that's not necessarily comparative analysis. That's a description, and it's a good start. That is certainly necessary to describe things that take place in operation, but then you have to provide the evidence that they did in fact occur in a comparable and no more stringent fashion for mental health, substance use disorder versus medical and surgical. So just wanted to harp on that one before we move on to the next one. Anything else, Sam, that you wanted to add?
No, I think we're good. All right, so a couple of points to make about the comparative analysis, in addition to the ones we just made, was as written and in operation are not the same inquiry. When we get into section 203, they're both bundled together in the step 4 requirements, but they are distinct inquiries. And you can pass or fail on either side, and you have either passed, well, you can pass on the as written side and fail on the in operation side. So therefore you didn't pass. Or you can pass on the in operation side, but didn't pass on the as written because of the processes and the requirements of the processes were much more stringent as applied to MHSUD benefits. So the as written and in operation are not the same inquiry. I'm being redundant on purpose. And in the reporting, they need to be treated and discussed and analyzed and an analysis provided for each component of that. There's often been a lot of confusion and meshing of this, and it will not be an acceptable form of reporting.
I might just add too, and again, and we'll bring up the spreadsheet again later that has some of the data reporting. I know some of you have some questions about that. Keep in mind that none of the data reporting in that spreadsheet, again, we understand very clearly that disparate results are not dispositive of noncompliance. That data is just necessarily to give a little bit more information for potential questions and inquiries, but nothing that will be determined that is non-compliant based on what that data indicates. And also, we are very aware that the determination of comparable and applied no more stringently applies across the classification and not with a service-to-service comparison. So we certainly don't mean to imply by breaking out some of those distinct facility types and so forth within that spreadsheet that we ever would think that you could say, oh, well, inpatient psych hospital, there's a higher denial rate than there is for skilled nursing facility. There you go, it's a violation. No. We understand that that's not how the rules work. We're just interested in getting some more discrete, more sortable information, but nothing that was going to be determined as an absolute of compliance or lack thereof. So just want to make sure that that's clear.
Yeah, I would just add to that, maybe as an example, Marilyn and I have run across not too long ago, that the in-operation analysis provided actually kind of concluded that maybe they weren't in compliance with the in-operation phase of what they were doing. And they acknowledged that, but said they were now exploring how to take corrective action. I think the point I want to make is, and it emphasizes the point of this exercise, is not to say we got you. It's to have proper reporting and analysis that actually compliance can be assessed. So if a issuer determines that in fact maybe there's something that was going on that they weren't aware of that they thought was an inequitable application, it's okay to acknowledge that. But what also would need to be said is, well, we're taking step A, B, and C to look at how we're going to redress this because we're not sure it's really parity compliant. All right, so now we get into section 203 or 42 USC 300 GG hyphen 26A in the hole, 8 in the hole, and FAQ 45. Now, how section 203 of the Consolidated Appropriations Act came about is a varied story, but what it really was about was a pushback, frankly, between regulators and issuers or carriers in various forums as to who had the burden of compliance demonstration. And the position that most regulators have held is that the burden of compliance is not for them to review countless documents to find a reason to say you're not in compliance. It's for the issuer or carrier to demonstrate that they actually are in compliance. So the burden is on the issuer or the carrier or whoever's offering the plan. Now, it's important to note that the way the new statute is constructed is that insufficient comparative analysis or determination that it's insufficient is now a direct violation of MHPAEA itself due to the provisions of the new section 203. And it specifically states that the issuer shall perform and document comparative analysis of the design and application of non-quantitative treatment limitations and make available to the applicable state authority that same comparative analysis. So again, it's not to the regulatory authority to develop a comparative analysis based on raw information provided by the issuer carrier. It's up to the carrier to offer up their rationale in a succinct, integrated manner for assessment by a state regulatory authority. And then if discussion is warranted, that's a different step. The second part that it came up in addition last April of 2021 was the federal agencies issued some guidance about how to interpret the new statute. We call it, and we're going to get into it in some detail, we call it the rule book for the sufficiency of a Section 203 comparative analysis. So that's kind of an overview intro to some screen sharing and other things we're going to do here. But Tim, I don't know, did you have another comment about the demonstration component of
I do, but I'm going to hold that until I bring up the statute on the screen. Just one thing just to add here, the second bullet point. While we note that insufficient comparative analysis is now a direct MHPAEA violation due to subsection A8A, don't misconstrue the intentions of this exercise are not to find people out of compliance with MHPAEA because they did not satisfy the comparative analysis requirement. We're just noting that that is technically an option that's on the table, but that is not an option necessarily being pursued here. I just want to make sure that you're clear about that. That was just a dry noting of what is now in the statute. Okay, so what I'm going to do, again, I'm going to jump out of the presentation. I'm going to bring up Section 203, or within 42 USC 300 GG 26 A8A, which is what Section 203 created. And we're going to walk through that, and also then we'll move into the FAQ 45, which, as Sam mentioned, is the sort of the rule book, or helps really provide more clarity and guidelines for how to comport with the comparative analysis requirements. So I'm going to jump here. Here we go from the dense NQTL text in the final rules to the dense NQTL text within the statute. So this is what Section 203 of Division BB of the Consolidated Appropriations, signed into law December 27th, 2020. This is what it added, and for the purposes of state-regulated health insurance issuers, this is all that is relevant. All the stuff below this that was added is only relevant for the federal regulators and entities subject to that federal regulation. So no one watching this presentation needs to worry about anything that goes beyond subparagraph A here. So the requirement, of course, is that upon request, and this is the department ODI is requesting the information for prior authorization concurrent review this year. But it is basically a stepwise process. And one thing that some of you students of the Department of Labor's self-compliance tool that we've mentioned numerous times, you'll note that there's been a stepwise process suggested for NQTL comparative analysis since April of 2018. That's when the Department of Labor first issued their self-compliance tool that did, in fact, outline a stepwise process. And it is very similar to what is now here. And in fact, as FAQ 45, and we'll get into that in a little bit, notes that before this was suggested, now it's required with a little bit of tweaking. But the 5 steps here. So you have the specific plan or coverage terms or other relevant terms and description of all mental health substitute benefits to which such term applies in each benefits classification. So again, that's this step here. Step 1 is basically laying out. We need to know about the NQTL. In this particular classification, we just need to know all the information that's relevant to it. The second step, step 2, is the factors used to determine the NQTL will apply to mental health or substance use benefits and medical and surgical benefits. So a lot of times when we're talking prior authorization and concurrent review, in this case, for the issuers watching this presentation, what factors did in fact trigger prior authorization in a particular classification event? So you have, let's say, prior authorization in the outpatient other classification of subclassification benefits. What factors did in fact trigger that to apply to the particular mental health or substance use benefit, and what were the factors that triggered the NQTL to apply to the medical and surgical benefits in the classification? And again, as we've noted before, factors don't necessarily have to be identical. Comparable does not, but there has to be an explanation as how they are comparable. Step 3, the evidentiary standards used for the factors identified in clause 2, when applicable. And this is very important, provided that every factor shall be defined and any source of evidence relied upon to design and apply the NQTL's mental health or substance use benefits and medical and surgical benefits. What's important, what I've highlighted on the screen, is every factor shall be defined. So if you do list a factor and the factor has some factors might be self-evident, but there are some factors. So, for instance, risk of fraud, waste, and abuse. That might be a factor that has triggered concurrent review for a particular mental health or substance use benefit, and also it has triggered concurrent review for medical and surgical benefits. But we need to know the definition of what exactly constitutes fraud, waste, and abuse, and if in fact the thresholds for what is considered fraud, waste, and abuse are in fact comparable and no more stringent for mental health and substance use or benefits than for medical surgical. So if you do list a factor that applies, just say excessive high cost or excessive utilization, or there's some factor that you're listing where there can be a threshold or parameters or benchmarks for that factor, you do have to provide a definition that is clear enough to demonstrate, to prove that it is in fact comparable and no more stringent. So if you're going to list factors that potentially have a definitional component to that, like risk of fraud, waste, and abuse, or or risk to patient safety, you have to make sure that there's a definition provided that makes it's easy, it's clear to tell that in fact definition is in fact comparable and no more stringent for mental health versus medical and surgical when you apply that factor. Now the fourth step, and this is the step where a lot of the action takes place and where a lot of the comparative analysis will be occurring. And of course it contains the term comparative analyses. And it's the comparative analyses demonstrating, and I'm going to highlight this term here, demonstrating, and get to that in a moment, that the processes, strategies, evidentiary standards, or other factors used to apply the NQTL to mental health or substance use benefits as written and in operations, that's a two-part test there, it's both as written and in operation, are comparable to, applied no more stringently than, processes, strategies, evidentiary standards, other factors used in applying the NQTL to medical surgical benefits. So this is where you have to provide those comparative analyses so that any of the processes, strategies, evidentiary standards, or factors, they need to be compared and analyzed against the very same processes, strategies, evidentiary standards that apply to medical and surgical. So the processes, strategies, et cetera, that apply to mental health or substance use, or the NQTL, in this case, concurrent review or prior authorization, classifications of benefits, you need to have the comparative analysis that demonstrates that they are in fact comparable. And the reason demonstrating is highlighted is that's actually a pretty high standard. This is now a statutory requirement that the issuer must demonstrate. So the comparative analysis must demonstrate. And then I don't mean to belabor this too much, but if you look at, let's take the Merriam-Webster dictionary definition of demonstrate, you'll see to show clearly, or to prove or make clear by reasoning or evidence. So in other words, if we're accepting these definitions of Merriam-Webster, and Oxford Dictionary has a very similar definition, you must show clearly. That's what the definition of demonstrate means, or to prove or make clear by reasoning or evidence. So as we get back to the actual statutory text, that's the threshold here. So your comparative analyses must make clear to someone who is reviewing the comparative analyses that they do in fact show that the processes, strategies, evidentiary factors, and standards and factors are in fact comparable and applied no more stringently. So that's just want to make sure that we're clear with the security in place within this important step 4 is that you really do need to make clear that there is in fact compliance. And then the final step is the specific findings and conclusions reached by the issuer, including any results of the analyses. So if you've done the analyses, the results need to be provided that indicate the issuer is in fact in compliance with this section, which of course means this entire section. Sam, is there anything, Sam, Marilyn, anything you want to add on top of this?
Yes, and not to belabor the point, but the in operation and as written comparative analyses are separate, and they need to both be done. It cannot be a combined response.
Yeah, and if we say it 3 times, it must be true. So it is.
Okay, so
that's all, Tim, for this.
Okay, so now we're going to move on to FAQ 45. So first, we'll just give you a little context. And this, of course, was issued on April 2nd, 2021, and it is expressly about the new amendment to MHPAEA, which was signed into law on December 27, 2020. But the important steps here, there's a number of questions within this document. First of all, there's some background on the Consolidated Appropriations Act. Again, it lays out what we just went through there, the statutory text. Highly recommend. I'm sure all of you have in fact reviewed this very carefully, but if you have not, or you've only looked at it once or twice, I would say study this document in great detail to understand what the comparative analysis requirements are, as statutorily obligated by the statute 42 U.S.C. 300 GG 26 A8A, but also as the federal tri-agency's guidance is to how to do the comparative analyses. Now you'll notice there are a number of questions in this FAQ. I believe there are 8 or 9. Yes, there are 9, and they're all very important. But what's most important for the issuers watching this presentation are questions 2 and 3. And so essentially what questions 2 and 3 do is they lay out, question 2 basically lays out what constitutes or some guidance for what would make a comparative analysis appropriate. And then question 3 lays out some guidelines for what might make an insufficient comparative analysis. So just going through these, and again, we're not gonna read these all word for word, but it's important that you go through these and understand that this is sort of the guidance that will really help you understand how to best do these comparative, or how to meet the statutory requirements of the comparative analyses. So, clear description of specific NQTL, identification of the MHSUD and medical surgical benefits the NQTL applies to each benefit classification, clear statement which benefits are treated as MHSUD, which are medical surgical. You have to identify the factors. Again, this is sort of going through, just helping unbundle the statutory text. For instance, analyses should explain whether any factors were given more weight than others and the reasons for doing so, including an evaluation of any specific data used in the determination. As we just mentioned, the extent the plan or issue defines any factors in a quantitative manner, it must include precise definitions used in any supporting sources. That's the step 3 of the stepwise process that we just had up on the screen. Analyses should explain whether there's any variation in the application of a guideline or standard used by the issuer between MHSD, and if so, the process and factors for establishing that variation. So in other words, as we've talked about before, if there is variation that's different between mental health substance disorder and medical surgical, that's okay. It's just you need to make sure that you can demonstrate and describe the processes and factors used for establishing that variation, showing how it is in fact comparable and it's not more stringently applied. If the NQTL turns on a specific decision in the administration of benefits, the planner should identify the nature of the decision makers, timing of the decision, qualifications of decision makers. And one thing just to note, not all of these guidance points here are going to be applicable for each NQTL or for each classification of benefits. So sometimes not all of these will be applicable for any given cell of a comparative analysis. Experts guidance, if you have the assessment of experts' qualifications, reasoned discussion of the issuer's findings, conclusions to comparability, process, strategies, standards, factors, both as applied and as written. And so any citations, specific evidence considered, and results of the analyses, again, that's results of analyses is very important that you're able to show those. And the date of the analyses and times of positions of people. So again, this is all good guidance to help you understand, what would make a nice, robust, and sufficient comparative analysis. And of course, there's certainly other things, and it's not as if every one of these is going to be applicable at all times, and there's going to be times when there's other things that are not stated here that might be applicable. But again, it's good guidance to help you as you're doing your comparative analyses. And then for question 3, now this is more of the probably shouldn't do this if you're doing a comparative analysis when you do your comparative analyses. These are sort of the do not do's. As you'll notice here, the tri-agencies said issuers should avoid, and that's these following things. So a production of large volume of documents without a clear description of how and why each document is relevant to the comparative analysis. This is very important. And we're going to get into this when we bring up the comparative analysis collection tool that you're all going to be filling out. But the purpose of the comparative analysis requirement is that the comparative analysis be done by the issuer, and then that is reported in the reporting steps. So in other words, if you're going to, if there's a submission that has, let's say one of the say step 4 says, see clinical policy bulletins 7, 8, 12, and 14, and mental health and medical surgical clinical policy bulletins 2, 3, 7, and 12. that's not a comparative analysis. The purpose of the comparative analysis requirement is that the issuer look at those documents for mental health and substance use disorder, the clinical policy bulletins or whatever documents, or utilization management manuals, clinical policy, whatever it may be. The issuer looks at the documents, compares them and contrasts them, and then reports on what they have found. So that's the purpose of the comparative analysis step. So in other words, a comparative analysis really, they need to be self-contained within the reporting format. So you can certainly include attachments and so forth and say, see page 37 of clinical policy X, Y, or Z for the proof that our conclusion here is in fact true. But the purpose of the comparative analysis is that the issuer examines all of those documents, does a comparative analysis, and then reports on what it was that they found and how they knew that in fact it was comparable and applied no more stringently. Second, do not do conclusory or generalized statements where there's basically a recitation of the legal standard of 45 CFR 146.136 C4 without any evidence, detailed explanations. Again, so it's not as if you have to write a novel for each step of the comparative analysis requirement, but one or two sentence answers that's probably not going to be sufficient. If it's just saying that we did analysis and we did in fact determine that the process, strategies, evidence, and other factors were comparable and applied no more stringently, both as written and in operation. That's not really an analysis. That's just a simple conclusion that needs to be backed by evidence and support. Again, identification, this is something that we talked about a little bit earlier. Identification of processes, strategies, sources, factors without the required clear, detailed comparative analysis. So identifying a process, let's say, that is very important, and you do need to do that, but then you have to go further and provide the clear and detailed comparative analysis. Just identification of processes, strategies, sources, factors that apply, particularly in operation, you need to go further and do the actual comparative analysis. Identification of factors, evidence, without a clear explanation of how they were defined and applied in practice. Again, getting back to the definitional component. Reference to factors and evidential standards that were defined or applied in a quantitative manner without precise definitions and information necessary to assess their development or application. And of course, the last one, analysis that is outdated due to the passage of time. I'm sure no one will do that. But again, as we highlighted quite a bit, when looking through the statutory text, that definitional component is very important, as this tri-agency document has indicated. And also the comparative analysis, the demonstration component, that is very important, which again was emphasized by these two FAQ, the Q2 and Q3. Sam and Marilyn, I'm sure you guys have quite a bit of commentary you'd like to add on this as well.
Yeah, we do. I'll lead it off with echoing or channeling you a little bit and going back to the statement about how density should not be confused with ambiguity. In a sense, there's a lot of information here, but it's not ambiguous at all as to what's required. The second point I want to make before discussing some specific issues is what we're about to discuss will be in a slide format which will be posted along with this recording. So you don't have to take copious notes because the points we're going to make are essentially there. But what we've done is we've taken all the information that Tim just went through, and now that we have a common framework of the 5 steps that are required by the federal statute, we have offered an analysis of which of questions 2 and 3 and their respective elements actually apply to each step and why they're important. And we'll offer some experiential data from what we've seen that's good or bad. But with respect to step 1, that FAQ 45 question number 2, numbers 1 and 2, the guidance is really clear that the step 1, you got to identify the NQTL, the benefits to which it applies, and so on. And those questions specifically stipulate that a sufficient analysis must include a clear description of a specific NQTL, the plan terms and policies at issues, and identification of the mental health, substance use, and medical surgical benefits to which it applies. Now, that may all seem straightforward, but a 1-sentence iteration at step 1 that, see the benefits book attached, that is not a sufficient explanation and is not correlate with what the guidance FAQ 45 provides. So we have this specifically stipulated as to which of the questions we think are most pertinent to which step. And in some cases, they apply to more than one step. But that's it. And Marilyn, I don't know if you want to comment on things we've seen at step one, other than the one I mentioned that, it's a one sentence C, the benefits book or the attached summary plan description.
Yeah, I mean, I think a lot of times we see no description, either just an identification of what the NQTL is that they're discussing, or the one sentence description. It is important that a description is provided. I think it is okay and sometimes helpful to reference a separate plan document, but that should be in addition to that description. And if you are providing a reference to another document, the document should be clearly named and identified by page number so that the reader doesn't have to go figure out what you would deem to be important. It should be relative to that clear description and just as proof and evidence that it exists in the summary plan description or the benefits document that you're referencing.
Yeah, that's a really important point, and it comes off as something that we need to repeat over and over again, that the analysis provided in the required reporting format needs to be self-contained. We welcome additional information that you think supports what you've summarized for any respective step, or helps expound on it, but it's not handing over an entire document and say, see this 212 page thing. We want the specific page references and whatever, and an explanation as to why it is relevant. But documents being attached is not a substitute for a clear explanation. Now, that's step one. Now, step two, you want to talk about that a bit, Marilyn? I can ad lib in additional things if appropriate.
Sure. So as you move down to in question 2 to number 3, you see that this is a reference to the factors, evidentiary standards, sources, or other strategies and processes. And you see the use of the word any. So it says identification of any factors, etc. So that means that factors, evidentiary standards, and sources provided needs to be an all-inclusive list. Frequently, we see words like the factors include. The word include would indicate that that isn't an all-inclusive list. So in order to understand the way that the plan is designing and applying the NQTLs, the list has to be all-inclusive. In addition, as you also see in number 3, there is the reference to weight and explaining whether any of the factors are given more weight than others and the reasons for doing so. This is often something that is not provided, but yet is important to know how the analysis is being conducted, what's the weight the factors are being given by the plan in applying the NQTL. If we move down to number 4, okay. And this refers to actually step 3, where it requires the plan to define the factors, evidentiary standards, and strategies. Oftentimes we see, factors being introduced in step 2, and then additional factors being addressed in step 3, and sometimes even factors being addressed in step 4. So you actually want to see an all-inclusive list of factors in step 2, and then definitions of those factors. As we, precise definitions of those factors and supporting sources. As we move down to question number 5, it says reference to the factors and evidentiary standards that were defined or applied in a quantitative manner without precise definitions, data, and information is insufficient. So where you have a quantitative factor, it's necessary to have a precise definition of that factor. Sam, do you have anything to add?
Yeah, I would just add from some observations we've had that the inclusive comment you made, Marilyn, is really important. And in fact, not only sometimes does it say it includes, sometimes the word include is prefaced by the word may include, which is even more confusing as to what's really being applied here, because what we're looking for is that the factors that trigger, if you will, the NQTL actually have comparabilities between medical surgical and MHSUD. And another point that we've experienced a lot is that even we get a pretty good list of factors in step 2. And as Marilyn pointed out, you got to define them in step 3. Well, they're not defined. And then there's a concluding paragraph that says, in addition, these are other factors that may be relevant. Well, why weren't they listed in step 2? And I think what I'm really getting at here is the way these steps are laid out, there's an inherent logic to what they are, and that the reporting submission should be self-contained and consistent with what each step requires, because they do have different elements as to what they require. I don't know, Tim, do you have anything you want to add on step 2 or 3?
No, I mean, I think this has been very comprehensive, and I think, again, I know it seems like we're sort of harping on the definitional component, but it is very explicitly stated in the statute that every factor shall be defined. So that's why we're harping on that. We're also harping on the demonstrate definition, is that those are some of the linchpins of the statutory text, and so we just want to make sure that you're clear what the standard is within the statute, the statutory text, and this guidance here is very helpful to helping unbundle the statutory text. As we've seen up on the screen, the NQTL final rules from 45 CFR 146.136C4, they're very dense. And then, of course, the NQTL statutory text from 300 GG 26A8A is also very dense. And there's a lot to unpack here. And as Sam and we've said before, though, it is not ambiguous. It's just that there's a lot to unpack. And so we strongly recommend that you take a look at this guidance, because this really will help you unpack some of the thorny realities of the statutory text, and of course also the regulatory text as well, from 45 CFR 146.136. But no, I think that's it here. Sam, do you or Marilyn have anything else on this document?
Well, not on steps 1, 2, or 3. A few comments on step 4 and 5 that go to question 3, number 4, Tim. That part of what the analysis is, not only do we want those factors defined, we want to know how they were applied in practice. That you can say that all these factors apply, but if a whole different set of factors is being applied to trigger medical surgical versus MHSUD, that's quite different. And that may be okay, as we've indicated before, but you've got to explain why they're comparable, because they are different on their face. We want that. Then if you go to Q3, number 3, we want an identification of the processes, strategies, and but we need the detailed comparative analysis. So as Tim kind of alluded to before, or was explicit, that just to say that we drove to work the same way, or we did the same thing, that's descriptive. That's not a comparative analysis. That the processes and the content of the processes as written are actually going to be the same. And in some cases it has in operation components, and will lead into at some point here the data elements you're required to report on. So again, in Q3, number 2, the conclusory generalized statements, we've seen this over and over and over again, where it essentially there's a 1 or 2 sentence declaration that we did an analysis, we determined we're compliant, therefore we're in parity. Well, you've got to tell us about what that comparative analysis was, and a reasoned discussion as to how you reached the conclusion that your analysis and conclusions were consistent with what the regulation requires. Marilyn, you may want to add something before you do. All I want to say is that, again, in operation as written are different. We need a comparative analysis, and this guidance provided by FAQ 45, and where we think specific elements of that guidance apply to specific steps 1 through 5 will be posted on a slide. So you can have that and study it yourself. Marilyn, you got anything you want to add?
Yeah, I mean, I think it's not uncommon to see in step 2 where the plan will say the factors for both MHSUD and medical surgical are nearly identical, or they say they're the same, but on their face they're not the same, or they say they're similar. The spot to really discuss that is in step 4. So if you have differences that you've provided in steps 1, 2, or 3, you have to prove comparability in step 4 and tell us why it would be comparable, even if they're not the same on their face. So this then proves why steps 1, 2, and 3 need to be specific, all-inclusive, and the plan needs to provide descriptive information.
How about step 5?
Step 5. So step 5 is your conclusion, which needs to be, you need to provide a reasoned discussion. And so sometimes we see no conclusion whatsoever, or we see the conclusion kind of stuck in step 4 or steps 1 or 2. And the plan really needs to provide a conclusion that has specific findings and a discussion of why they're in compliance.
We're good. So I would only add, I guess, in a conclusory way to repeat that these steps 1 through 5 and the element requirements for each are also sequential and interrelated. It really is not possible to get to a good discussion at steps 4 or 5 or a conclusion without fulfilling the steps that precede it. So with inadequate analysis at steps 1, 2, 3, and 4, and both as written in operation in step 4, a generalized or conclusory statement at step 5 that we're at parity just is not sustained by what was demonstrated. So that's my conclusion on that, Tim, if you want to move on.
Yeah, and just to note, I mean, of course, we're talking of examples that we've seen. This is not to suggest that we expect any issuer in Ohio to have these same challenges that we've seen in other. Just pointing out some of the problems that we've seen in some areas. But again, this is something that this is like the point of this exercise is not to trip anyone up. It's to help everyone come to compliance with these new requirements that are in fact quite dense and thorny. And again, this guidance is a great place to start. And of course, questions are always welcome to the email address that was shared earlier that will be shared again at the end of the presentation. So what we want to do now is go touch on the form. And again, this is the form that you all will be filling out for prior authorization and concurrent review. We're not going to go through 88 pages of this document. This is obviously, we're just going to talk about it. But and there's the introduction here. Again, you see it, FAQ. There's a link to FAQ 45 within this document. So again, it's another place to look. Also, the self-compliance tool that we've mentioned from the Department of Labor, a good tool and resource. Although just please note that any of the NQTL guidance within the self-compliance tool predates the enactment of Section 203 of Division BB of the Consolidated Appropriations Act. So just keep that in mind, is that things that you see in the NQTL comparative analysis content within the self-compliance tool it does in fact predate the actual statutory requirements. So, but if you look at the document here, I think we're not going to go through the entire document in terms of, and of course, if you have questions about this document, please reach out to the department at the email address that is listed. Will be shown again near the end of the presentation. And we're going to go into the spreadsheet as well in a moment. But here you see the definitions of prior authorization, concurrent review, ambulatory services. But then what I want to get into is now as we lay out the stepwise process. So this is for prior authorization. Again, within this document, it does list FAQ, what the relevant questions within Q2 for step 1. So again, please refer to that. And this, again, we're not going to go, we've obviously gone into great detail about what all the actual requirements are. But again, it's a restatement of the statutory requirement for step 1. And then, you have the general description, the types of plans that the prior authorization information applies, the coverage terms, and then again, page number. If there is references to other documents, please include the page numbers for ease of reference. And then as you go out, and here is the benefits classification. You have in-network, inpatient, mental health substance use disorder, medical and surgical. And you have inpatient, out-of-network for step 1. So again, that's how this is structured. You do each step for each benefit in the subclassifications if you do use them. Outpatient, in-network. And again, if you have no network, if you have no network plans, you should be filling these out for the out-of-network classifications. For instance, outpatient, out of network, that's where you would fill them in here. Outpatient, out of network, emergency, and then here's prescription drugs. So those are the 6 classifications of benefits: inpatient, in network, and out of network, outpatient, in network, out of network, prescription, and emergency. Then you get into step 2. And again, we're not going to go through all of this and belabor this, but step 2, it has the FAQ Q2 guidance that was helpful. It also includes the statutory text, and you have a similar exercise to what was done for step 1. We'll just breeze through this because we already showed you the format. Then you get to step 3. Again, it gives you the FAQ 45. It gives you the statutory text and also the FAQ 45 guidance. And then as we get into step 3, this is where the Q3 guidance, just to remember what you want to avoid. It gives you which questions within the within Q3 are relevant to help you avoid making any mistakes that might be problematic. And of course, you have the same submission format that we had for the other steps. We'll just breeze right through that. Then you get to step 4. Now, step 4, as we've mentioned before, this is the one where most of the action happens. This is the step that probably requires the most work. You have the statutory text, and as you'll see here, as I know we've gone through that FAQ 45 guidance quite a bit, but again, it's restated here. Here's the Q2 guidance that you want to abide by and then really pay attention to when completing step 4. It's Q5, Q6, Q7. But then when you get into the things you want to avoid, that has the Q3 guidance for things that you probably want to stay away from, number 1, 2, 3, and 4. And again, you have the same submission format that you had for the other steps. We'll just breeze right through that. And then we get to step 5, and again, this is the conclusion step. And then again, you have the Q2 guidance that you want to think about when doing step 5, and then the Q3 guidance. And of course, you get through all of the submission format through here. And then, of course, this then repeats itself for concurrent review. So that what you just saw was prior authorization, then it does concurrent, and then we move into concurrent review. So now what we're going to do is we're going to bring up this document here. Sam and Marilyn, any comments you had on this doc before I move on?
No, just that by design, that reporting format is in a Word document, so you're not squeezed into an Excel spreadsheet to explain what you want to explain. That's all. And it is the format we expect to get the feedback on.
Sam, this is Laura. If I could just jump in one moment there. This is actually a PDF version because we have to have PDF because of SURF requirements, but they still should have enough space to respond.
Okay, good. Thank you.
All right, so now bringing up the spreadsheet. Now we looked at the spreadsheet, obviously, for the financial requirement and quantitative treatment limitation information. And as we have here, though, as you note, there are other tabs that have information in them. And so what we have is we have tabs there's one for mental health, one for substance use disorder, one for medical and surgical. And as you'll note, there are for inpatient and outpatient, there are some facility types. Let's just take a look at mental health for now. So you have general hospital, psych hospital, residential. That's the inpatient in-network, and we do the same things repeated for out-of-network for both inpatient and outpatient. So there's just some data we're interested in here. The department's interested in knowing about number of PAs prior authorization requested, number approved, And again, none of this information will be used to find anyone out of compliance. It's not as if, we understand that disparate results are not dispositive of noncompliance. That is very clearly stated in the final rules and in the preamble to the final rules. And on the other hand as well, very similar results are not necessarily dispositive of compliance. We're just interested in getting a greater picture of how things are looking in operation, just in terms of the outcome metric side. Things like determining, number of prior authorization requests to result in approval, the number of first level prior authorization requests that go to second level review. Just so you're clear about what we're talking about here, this doesn't mean appeal or anything like this. First level prior authorization request sent to second level. Well, that means we have that first level utilization reviewer that can only approve but cannot deny an authorization. How often are they sending that to the second level physician reviewer? In other words, the second level physician reviewer is the one who could deny or still approve the authorization. And again, it's broken out by facility type. Again, we are not at all, don't think that we're going to look at this data, anyone's going to look at this data and then go look at medical and surgical and say, aha, they have for residential treatment, the number of prior authorizations to auto-adjudicate for payment is 32%, and for medical surgical skilled nursing facility, it's 18%. That's a violation law. No, that is not at all the intention here, and we never expect that. We're just trying to get a richer picture of what's going on, most likely, particularly in the in-operation realm. This is just informative data for the department's use, maybe potentially to spot red flags, potentially sort of a smoke alarm. But again, this data by itself will not be used as dispositive form of non-compliance. So we don't want anyone to think that that's the purpose of this spreadsheet. Sam or Marilyn, anything you wanted to add?
Yeah, Tim, I would add on to what you just said, that you, Marilyn, and I are not of the school that is data driven in terms of analyzing compliance. Our experience with a lot of data reporting is that sometimes it may yield an indication we should probe something different, but it is as likely to produce false positives as it is false negatives. And that requires some analysis and report. But just so to reiterate what you're saying is, we are well aware that this data can engender false positives and false negatives, but sometimes may engender an additional question for clarification.
Yes. Okay. So with that, we will jump back out of this and into sort of the conclusion of the slideshow. Just move here. That slide. Okay. So as you can see, the reporting deadline is February 28th. That's about 6 weeks from now, or yes, about 5.5, 6 weeks from now. So it's a good amount of time. And again, as we've noted before, certainly available for the department's available for answer any questions. And here you see, again, here's that email address, MHPAEA compliance questions at insurance.ohio.gov. And of course, there will be an accompanying PDF version of this slideshow that will go out that will have obviously the statute in Ohio Revised Code 3902.36. That's the statute providing the department would implement the law, and of course the new subsection of the underlying MHPAEA statute, subsection A8, with subparagraph A being most relevant. That obviously we've showed that on the screen. That's the relevant statute, and also of course the FAQs will have links to that as well. And then of course the Department of Labor self-compliance tool. That of course will be provided as a link as well, as a very, very helpful information in looking into that, particularly for the quantitative and financial requirement, as we've mentioned earlier. There's a lot of good information there that can really help you out. For the non-quantitative, I would certainly recommend looking at the self-compliance tool, but I think FAQ 45 is probably a little bit more relevant because it was published after the new statutory requirements went into effect. With that, Sam or Marilyn, is there anything that you'd like to add on top of that?
No, I think we're good.
Okay, well, with that, that concludes this presentation, and we hope that you are able to follow. And again, any questions, please do submit them to MHPAEA compliance questions at insurance.ohio.gov.